I'm Josh Gablin at Gablin Law. In this video, we're going to be looking at David Millette and Ruslana Petryazhna v. OpenAI Inc. It's a first amended complaint in a class action lawsuit filed October 18th, 2024. Let's get into it. To briefly sum up this case, we have 4 counts that are being alleged. We have an unfair competition claim, we have an unjust enrichment claim in California, we have an unfair competition claim in Massachusetts, and finally we have a copyright claim. And these are on behalf of the class of YouTube creators against OpenAI Inc. Please make sure to subscribe. This complaint was filed in the Northern District of California Federal U.S. District Court, and it is a class action lawsuit. Plaintiffs, David Millette and Ruslana Petryazhna, collectively plaintiffs, bring this action on behalf of themselves and all others similarly situated against defendants OpenAI Inc. and OpenAI OpCo LLC, collectively OpenAI or defendants. Plaintiffs seek to recover injunctive relief and damages as a result of defendants' unlawful conduct. Plaintiffs make the following allegations pursuant to the investigation of their counsel and are based upon information and belief, except as to the allegations specifically pertaining to themselves, which are based on personal knowledge. Nature of the case. ChatGPT is a software product created, maintained, and sold by OpenAI. ChatGPT is currently powered by artificial intelligence, hereafter AI software programs called GPT 3.5, GPT-4, and GPT-4o that are also known as large language models, LLMs. A large language model is trained by copying massive amounts of text and extracting expressive information from it. This body of text is called the training data set. Once a large language model has copied and ingested the text in its training data set, it is able to emit convincingly naturalistic text outputs in response to user prompts. Large language models' output is therefore entirely and uniquely reliant on the material in their training dataset. Every time they assemble text, video, or image outputs, the models rely on information extracted from their training dataset. This case addresses the surreptitious non-consensual transcription of millions of YouTube users' videos by defendants to train defendants' AI software products. For years, YouTube has been a popular video sharing platform that allows content creators and users to upload and share videos with audiences worldwide. However, unbeknownst to those who upload videos to YouTube, defendants have been covertly transcribing YouTube videos to create training datasets that they then use to train their AI products. Plaintiffs and class members are YouTube users and music and video creators. Plaintiffs and class members are YouTube users and music and video creators. Plaintiffs and class members have retained ownership rights in their uploaded videos per YouTube's terms of service. Plaintiffs and class members did not consent to the use of their videos as training material for ChatGPT. Nonetheless, their materials were transcribed and used to train ChatGPT. By transcribing and using these videos in this way, defendants profit from plaintiffs' and class members' data time and time again. As defendants' AI products become more sophisticated through the use of training datasets, they become more valuable to prospective and current users who purchase subscriptions to access defendants' AI products. By collecting and using this data without consent, defendants have profited significantly from the use of plaintiffs' and class members' materials, violated California's unfair competition laws, and infringed upon plaintiffs' ownership rights in their works, and have been unjustly enriched at plaintiffs' and class members' expense. I'm going to skip over the jurisdiction and venue here. The parties. Plaintiff David Millette is a citizen of Massachusetts and resident of Douglas, Massachusetts. Plaintiff created a YouTube account in or around June 2009. During that entire time, Plaintiff Millette has retained ownership rights to the video content he has uploaded to YouTube per YouTube's terms of service. Plaintiff Ruslana Petryazhna is a citizen of New York and resident of Astoria, New York. Plaintiff Petryazhna created a YouTube account in or around 2008. During that entire time, Plaintiff Petryazhna has retained ownership rights to the video content and numerous songs she has uploaded to YouTube per YouTube's terms of service. More, Plaintiff Petryazhna has registered her copyright of those works with the U.S. Copyright Office, including her song A Bubble World, which was uploaded to YouTube 15 years ago. Defendants transcribed plaintiffs' videos to train their AI software products. Defendant OpenAI Inc. is a Delaware nonprofit corporation with its principal place of business located in San Francisco, California. Defendant OpenAI OpCo LLC is a Delaware limited liability company with its principal place in business located in San Francisco, California. These are both the same address. I'm not reading the address. OpenAI OpCo LLC is a wholly owned subsidiary of OpenAI Inc. that is operated for profit. OpenAI Inc. controls OpenAI OpCo LLC directly and through other OpenAI entities. Each defendant acted jointly to perpetrate the acts described herein. At all times relevant to the allegations in this matter, each defendant acted in concert with the knowledge and approval of, and or as the agent of the other defendant within the course and scope of the agency regarding the acts and omissions alleged. General background. OpenAI creates and sells artificial intelligence AI software products. AI software is designed to algorithmically simulate human reasoning or inference, often using statistical methods. Certain AI products created and sold by OpenAI are known as large language models. Large language models, LLMs, are types of AI software designed to parse and emit natural language. Though LLMs are software programs, they are not created the way most software programs are, that is, by human software engineers writing code. Rather, LLMs are trained by copying massive amounts of text from various sources and feeding these copies into the model. During training, these models copy each piece of information in the training dataset and extract expressive information from it. The LLMs progressively adjust their output to more closely resemble the images, videos, and sequences of words copied from the training dataset. Once these models have copied and ingested all these inputs, they are able to emit convincing simulations of natural written language, as well as videos and images as they appear in the training dataset. As the USPTO has observed, LLM training almost by definition involves the reproduction of entire works or substantial portions thereof. Much of the material in OpenAI's training datasets, however, come from works, including videos created and uploaded by plaintiffs that were copied by OpenAI without consent, without credit, and without compensation. Specifically, OpenAI made a series of LLMs, including without limitation GPT-1, released June 2018, GPT-2, released February 2019, GPT-3, released May 2020, and GPT 3.5, March 2022, 4, March 2023, and GPT-4o, May 2024. GPT is an abbreviation for Generative Pre-trained Transformer, where pre-trained refers to the use of textual material for training, generative refers to the model's ability to emit text, and transformer refers to the underlying training algorithm. OpenAI offers certain language models in variant forms. For instance, the GPT-4 family of models includes publicly accessible variants, and the GPT 3.5 Turbo family of models includes publicly accessible variants. OpenAI has made other language model variants that are in commercial use but are not publicly accessible. In an interview with the Financial Times in November 2023, OpenAI CEO Sam Altman confirmed that GPT-5 is under development. Together, OpenAI's LLMs, including any in development, will be referred to as the OpenAI language models. Many kinds of material have been used to train large language models. Video transcriptions, however, are a key ingredient in training datasets for LLMs because they offer copious examples of natural language. In 2022, OpenAI released an automatic speech recognition ASR system called Whisper. The Whisper model, which transcribes audio into text, was trained on 680,000 hours of data collected from across the web. Tellingly, the exact names of the speech recognition corpora on which Whisper was trained are unavailable, but one of the world's largest open multilingual speech corpora, Vox Populi, contains only 400,000 hours of unlabeled speech data. LibraHeavy, an ASR corpus considered one of the largest freely available corpora of speech with supervisions, only consists of 50,000 hours of English speech derived from LibriVox. There are only a handful of publicly available internet-based speech corpora that can be utilized as training data for LLMs. As demonstrated, the two biggest corpora combined, Vox Populi and LibreHeavy, still fall more than 200,000 hours short of the duration of speech that comprises Whisper's training dataset. The New York Times reported that Whisper is capable of transcribing the audio from YouTube videos, and that an OpenAI team that included OpenAI's president, Greg Brockman, transcribed more than 1 million hours of video from YouTube. This tracks with OpenAI's admission to the USPTO that the company produces AI products that draw on experience developing cutting-edge technical AI systems, including by the use of large, publicly available datasets that include copyrighted works. Defendants could have trained their LLMs using works in the public domain. They could have paid a reasonable licensing fee for those works. What defendants could not do is ignore protections afforded by virtue of plaintiffs' ownership rights in their respective works. As evident by congressional testimony, defendants' CEO Sam Altman acknowledged that, as for enabling artist control, OpenAI's training data comes from a variety of sources, including also by licensing content directly from content owners. Just not plaintiffs here. OpenAI's language model datasets include transcriptions of videos taken directly from YouTube, because these video transcriptions are one of the largest corpora of natural language data available for training and fine-tuning the OpenAI language models. Moreover, by directing its language models to scrape videos hosted on YouTube, a site that expressly grants the uploader retention in their ownership rights of the videos, defendants know, or should have known, of a strong likelihood that copyrighted content would be included in its scraping. In fact, ChatGPT offers an analysis of the works. ChatGPT's analysis of A Bubble World explains that the tone is lighthearted, reminiscent of childhood innocence, emphasizing the importance of play and joy in life, and that the lyrics typically reflect a longing of freedom and joy, contrasting with the constraints of everyday life. This suggests that the underlying LLM must have ingested the entire song during its training. Notably, Mr. Altman knows that OpenAI's unauthorized use of the creator's content for the company's benefit is problematic. In testimony to Congress, Mr. Altman explained that ensuring that the creator economy continues to be vibrant is an important priority for OpenAI. OpenAI does not want to replace creators. We want our systems to be used to empower creativity and to support and augment the essential humanity of artists and creators. And, in a subsequent interview, Mr. Altman explained that creators deserve control over how their creations are used. And here are the class allegations. Plaintiffs seek to represent a class defined as all persons or entities domiciled in the United States who uploaded any YouTube video that was transcribed and then used as training data for the OpenAI language models without their consent, the nationwide creator class. Plaintiff Millette seeks to represent a class defined as all persons or entities domiciled in Massachusetts that uploaded any YouTube video that was transcribed and then used as training data for the OpenAI large language models without their consent, the Massachusetts creator subclass, and collectively the creator classes. Plaintiff Petryazhna seeks to represent a class defined as all persons or entities domiciled in the United States whose registered copyright material within any YouTube video was transcribed and then used as training data for the OpenAI language models without their consent. The creator classes and copyright class together shall be referred to as the classes. Specifically excluded from the classes are defendants, defendants' officers, directors, agents, trustees, parents, children, corporations, trusts, representatives, and the list goes on there. Plaintiffs reserve the right to expand, limit, modify, or amend class definitions. Numerosity. On information and belief, thousands of individuals fall into the definitions of the classes. Members of the classes can be identified through defendants' records, discovery, and other third-party sources. Commonality and predominance. Common questions of law and fact exist as to all members of the classes and predominate over any questions affecting only individual members of the classes. These common legal and factual questions include but are not limited to the following: whether defendants violated the rights of plaintiffs and the members of the classes when they transcribed plaintiffs' videos and used those transcriptions as part of their AI software's training datasets, whether defendants' conduct violated the rights and protections afforded to holders of registered copyrights, whether defendants' conduct alleged herein constitutes unfair competition under California Business and Professions Code, whether this court should enjoin defendants from engaging in the unlawful conduct alleged herein and what the scope of that injunction might be, whether any affirmative defense excuses defendants' conducts, whether any statute of limitations constrain potential recovery, whether plaintiffs and the creator and copyright class members are entitled to restitution or other relief, and whether defendants' conduct alleged herein constitutes a violation of Massachusetts law. Moving to the causes of action. Count 1. Unjust enrichment or restitution. Plaintiffs bring this claim under the laws of the state of California. Plaintiffs bring this claim individually and on behalf of members of the classes against the defendants. To the extent required by law, plaintiffs bring this claim in the alternative to any legal claims that may be alleged. Plaintiff alternatively alleges this claim as a quasi-contract or non-quasi-contract claim for restitution or disgorgement. Plaintiffs and members of the classes unwittingly conferred a benefit on defendants. OpenAI misappropriated valuable information from plaintiffs and class members' videos to expand their AI software's training data sets and used that information to develop and improve their products. In using plaintiffs' information to refine their language models, OpenAI made their products more valuable to prospective and current users who purchased subscriptions to access them. Plaintiffs and class members received nothing from this transaction. Plaintiffs lack an adequate remedy at law and plead this cause of action in the alternative to the extent plaintiffs are required to do so. Defendants have knowledge of such benefit. Defendants have been unjustly enriched and retaining the revenues derived from the sales of their products trained on plaintiffs' and class members' videos. Retention of those monies under these circumstances is unjust and inequitable because defendants did not obtain the meaningful consent of plaintiffs and class members before using their videos described above. Moving on to count 2, unfair competition law under California law. The unfair business practices described herein violate California Business and Professions Code. The unfair business practices described herein violate the unfair competition law because they are unfair, immoral, unethical, oppressive, unscrupulous, or injurious to consumers, and because defendants use plaintiffs' videos for defendants' own commercial profit without the authorization of plaintiffs or the classes. Defendants unfairly profit from and take credit for developing a commercial product based on unattributed reproductions of those stolen videos and content. Each plaintiff suffered economic injury as a result of defendants' actions. Each plaintiff was deprived of the value of their works by being deprived of the right to control who can use their works for commercial gain. By doing so, defendants deprived plaintiffs money that would be owed to them had they consented or granted a license to use the work. Count 3. Massachusetts Unfair and Deceptive Business Practices Act. Section 2 of Chapter 93 of the Massachusetts Unfair and Deceptive Business Practices Act prevents the use of unfair or deceptive acts or practices in the conduct of any trade or commerce. Section 9 of Chapter 93 provides any person who has been injured by another person's use or employment of any method, act, or practice declared to be unlawful by Section 2 may bring an action in superior court for damages and such equitable relief, including an injunction as the court deems necessary and proper. Any person entitled to bring such action may, if the use or employment of the unfair or deceptive act or practice has caused similar injury to numerous other persons similarly situated, and if the court finds in a preliminary hearing that he adequately and fairly represents such other persons, bring the action on himself and other persons. Moving on to count 4, direct copyright infringement. As the rightful and legal owner of the registered copyrights in videos that were transcribed and then used to train the OpenAI language models, plaintiff Petryazhna holds copyright rights to those videos under 17 U.S.C. Section 106. Plaintiff Petryazhna and the copyright class members' works are original to their creators and are fixed in tangible mediums of expression under 17 U.S.C. Section 102A, 2, 6, and 7. Plaintiff Petryazhna and the members of the copyright class have duly and timely registered their copyrights in their works with the U.S. Copyright Office. Plaintiff Petryazhna and the copyright class members are legal or beneficial owners of the exclusive right to reproduce their copyrighted works in copies under 17 U.S.C. Section 106(1) and 2, as well as the right to refrain from such reproduction. Plaintiff never authorized OpenAI to transcribe and make copies of her videos, make derivative works, publicly display copies or derivative works, or distribute copies or derivative works. All those rights belong exclusively to Plaintiff Petryazhna and the members of the copyright classes under copyright law. To train the OpenAI language models, OpenAI relied on transcribing and harvesting mass quantities of YouTube videos from the public internet, including Plaintiff Petryazhna's videos. OpenAI transcribed and made copies of plaintiff's videos during the training process of the OpenAI language models without plaintiff's permission. Because the OpenAI language models cannot function without the expressive information extracted from plaintiff Petryazhna's works and others and retained inside them, the OpenAI language models are themselves infringing derivative works made without plaintiff Petryazhna's permission and in violation of her exclusive rights under the Copyright Act. Plaintiff Petryazhna has been injured by OpenAI's acts of direct copyright infringement. Plaintiff Petryazhna is entitled to statutory damages, actual damages, restitution of profits, and or other remedies where provided by law. Wherefore, plaintiffs seek the following: an order certifying the classes under Rule 23 of Federal Rule of Civil Procedure, an order declaring that defendant's conduct violates the laws referenced herein, an order finding in favor of plaintiffs and the classes on all counts asserted herein, compensatory, statutory, and punitive damages in amounts to be determined by the court and or jury, prejudgment interest on all amounts awarded, an order of restitution and all other forms of equitable monetary relief, for injunctive relief as the court may deem proper, and an order awarding plaintiffs and the classes their reasonable attorney's fees and expenses and costs. And they are also demanding a trial by jury. First amended complaint, again filed October 18th, 2024. We'll be keeping an eye on this one.